How are Illinois car accident settlements involving minors different from cases involving adults? Hi, I'm Josh Rohrscheib. I'm a personal injury lawyer in Central Illinois. And when we handle cases involving minors in car accident claims, there are a few things that are done differently when it comes to settling the case for the minor than for an adult. And the reason is, under Illinois law, there are many safeguards or protections to make sure that a settlement is truly in the best interest of the minor. So in this video, I'll speak to some of those differences. We have cases where maybe a parent and a child are in the car together, and I'll just use that as an example to help explain how the two cases differ. So first, for a parent in a car accident, if they want to settle their case and the insurance company is willing to offer a large enough amount of money that we recommend that the clients take the settlement offer, and the client wants to take the settlement offer, basically what would happen is the insurance company would send a release and the client would sign the release. We'd send it back. The insurance company would send a check. We deposit the check in our client trust account. We would pay the medical liens that we're required to pay after we've negotiated those down, and then we would issue a payment to our client. Now, in a case involving a minor, the process works a little bit differently. So if we want to settle a case for a minor, we recommend it. We think it's in the child's best interest. Maybe the parents also think that the settlement is in their child's best interest. If the child is, old enough to communicate with us about what they want to do, they also think it's in their best interest. We can't just have the parents sign a release typically and then settle the case. Now, in some cases that have a value under $10,000, in some jurisdictions, some counties in Illinois, you may be able to settle the case with just the parents signing a release. But certainly for settlements over $10,000, there's a different process that's necessary. Now, here's how that process works. We file a petition with the court to appoint a guardian over the minor's estate, or basically to administer the settlement funds for the minor. And that guardian would also be making a recommendation to the court about approving the settlement. So we also file a petition to approve the minor's settlement. So petition, or we may file just one petition that's called a petition to name a guardian and to approve a minor's settlement. After we file that petition, the court will appoint something called a Guardian Ad Litem. The Guardian Ad Litem is a neutral attorney whose only job is to advise the court about whether or not the guardianship recommendation and the settlement is in the best interest of the child. So the GAL will interview usually the parents or the petitioner. If the child's old enough, they'll also interview the child. And they'll prepare a report for the court and advise the court on whether or not they think the settlement's in the child's best interest. And then a hearing would be held on the petition to appoint a guardian and to settle the minor cause of action. And the parents would typically, or the guardian who's petitioning, the person petitioning the court to be named the guardian, would appear in court and be asked some questions. If the minor's old enough to participate, they would be asked as well. And if the court believes that the settlement is in the child's best interest, they will also consider the recommendation of the Guardian Ad Litem, and the court at that time can approve the settlement. One other thing that's different with the case of the parent, we just give a check to the parent. Now with the case with the minor, it works differently. In the petition to approve the minor settlement, we will lay out a proposal for the court about what will happen with the settlement money. And it may be necessary to keep the money in a special account controlled by the guardian where the funds are secured unless there's a court order authorizing them to be spent until the child is 18. It may be the case that we'll use something called a structured settlement that would basically provide payments for the child either when they hit 18 or sometimes at 18 and then a little bit after 18. One nice thing about a structured settlement is it provides a little more growth than other bank accounts. And typically, speaking of growth, typically the courts, when they look at these settlements, their main goal is to preserve the money for the child. So unfortunately, while in your own stock in or investment account, you may be able to take significant risks that can have significant returns, you're really, most of the time, courts want the funds for the minor to be invested in a way that doesn't expose the money to much risk. This can limit the returns that are available to the minor. We see some lawyers put these settlements just in like CDs that mature on a certain birthday. And each case is different, depending on how much money we're talking about, how old the minor is, the needs of the minor. whether they're going to need some of those funds for their care between now and when they turn 18. So we look at each case individually and try to craft a solution that maximizes the benefit of the settlement for the minor. And that's one of the things that an experienced injury lawyer can help you with. Because there's a little more involved in getting a case settled and approved for a minor, I think it's a particularly good idea to work with a lawyer if you're handling an injury claim for a child or a minor. If you have any other questions about personal injury law in Illinois, please don't hesitate to reach out, and I appreciate you taking the time to watch this video.